This is How to Sell a Business, Step-by-Step Guide, Part 2. My name is Tom Goldblatt. You can read about our financial poise on slide 2. And our panelists today, we've got a great group of panelists continuing our discussion. We've got myself, I'm managing partner of Ravinia Capital. We have Phil Buffington, he's a partner at Balch & Bingham, LLP. Jonathan Friedland, partner at Much Shellis. And joining us this time is Brad Pickard of Republic Partners. You can see our names on slide 6, and you can read our bio starting on slide 51. Neither Financial Poise nor we intend this to be an infomercial, so you don't have to listen to me read bios. If you want more information about us, just look at our bio slides. About the slides, I'll try to call your attention to slides that are relevant to whatever we are talking about, so you can take notes if you like. Don't worry if you're listening but not watching the webinar. You'll be just fine because the slides are not critical. And we are Financial Poise is in the webinar is sponsored in part by Mood, the nation's premier online retail cannabis dispensary, as well as Type to Learn, a Sunburst company, and Max X Exits. If you need to conduct an online auction, Max X Exit is your turnkey solution. The last thing before we begin is slide 5, contains a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. Without further ado, here we go. Now, part 1, we covered the first half of it, and we're going to start in the middle here with question 16. And this question is going to go to Phil. How should a seller handle key employees? In other words, how important is the management team in the sales process, and what steps should be taken to ensure they are on board and aligned with the sales objectives?
Good morning. That's a great question. And, you know, it's a question that I think in a lot of instances people overlook in the rush to get into a transaction with everything going on and the due diligence involved and negotiating the transaction. But it's really important for one reason. You've got obligations to continue to operate the business in the ordinary course of business until closing. So keeping management in place is very important, as everybody knows. You've got to allay some of their fears, and that is, if the business is being sold, what's going to happen to them? What's the impact? Are they going to have a job? If they do have a job, what's the job description going to be, and is it going to be really different from what they're used to doing? I think some of the things that you've got to do, and then we'll talk about some of the mechanisms to do it, is you've got to be communicating with management from the beginning. I think that's really important, because if you keep them in the dark, then they're going to be more concerned and have more anxiety. So communication and transparency to the extent possible. I realize that some things can't be transparent because of confidentiality, but to the extent possible, communication and transparency are important. But I think some of the mechanisms that you can use to keep management in place and happy that I've seen utilized, and they work on differing levels depending on the people and the company. And that's a really key point too, is every individual is different. So, you know, you can't just say one size fits all and this is going to work in every instance. But some of the stuff that I've seen happen is retention bonuses. If you'll stay through closing, we'll pay you a bonus to stay through closing and continue operating the company. And I think people see that a lot.
I've seen this all different ways, and maybe the other and these are good answers, Phil. You know, I've seen where people want to communicate to everybody right off, and other times it's a select group. And then, again, as you're saying, it depends on the situation, but generally it's going to come out. So it's good to communicate more proactively, so it doesn't get communicated in the rumor mill. I'm
A-
kind of interested in the other panelists too, that I've seen both kind of ways where you give a bonus to the management to close the deal. And I've seen other times where the buyer would prefer that they're kind of giving the incentive so that the management doesn't like almost cash out and want to leave at the end. Other panelists, do you have any thoughts on what's the best way to handle management and bonuses in a sale?
I'm happy to chime in. I agree with Phil in that, Tom. There is no one size that fits all. And I think the communication plan often has to dovetail with the retention plan. So, I'd say in most of our processes, we would typically counsel CEOs, families, business owners not to disclose until they really know that they're confident a transaction is going to happen. It can be too disruptive to do so otherwise. Of course, you always have to key in the people that are critical to help you execute your process. But by and large, that can, we run many processes with large organizations where only, less than a handful of people have been made aware of the transaction until you have something more definitive to disclose.
Yeah, and it really is important. What you were saying, Tom, is, I mean, you've got to get the word out sooner or later. And I think the sooner that the key people know, the better off you are. I mean, obviously, there are going to be some employees in any organization that it's not going to affect the value if they happen to walk out the door. It may affect the way things are operated day to day and may cause some inconvenience, but it won't affect the value. But rolling those out in stages, your key management people, your management team, C-suite people, and then really, if you're in the sales business and you've got products, making sure that your salespeople are out there knowing it and communicating the right message to the customers. That's going to retain the value. But the other stuff that I've seen is just a higher salary for a period of time. But let me back up to the retention bonus, because Tom, I think it was you, it could have been Brad that said something. If you're looking to keep the employee beyond closing, then you really are looking at buyer incentives there, where what they're doing is they're giving you a bonus based on the next 2 to 3 years of your performance after the acquisition. If you're only trying to keep them to closing, then you know what the quantified period is. But I see both programs working in transactions I've been involved with.
Yep. Well, we'll skip to the next question. Brad, on how long should a business owner realistically plan for the preparation phase before putting their business on the market? And what are key milestones in this timeline? Walk us through a traditional marketing process. That's a pretty big question.
It is. And again, I think all of us on the call would agree there is no one process that fits every buyer. I'm a big fan of trying to structure sale processes to fit our clients' objectives and priorities while dovetailing with the business, the attributes of the business, and ultimately the number of buyers that we want to approach ties into the seller's objectives and what type of process we're trying to implement. There is no one size that fits all. I really view the traditional sales process, Tom, was breaking down into 3 parts. There's the preparation, there's the marketing, and then there's the close. I think clients all too often want to go to the market quickly, because once they determine they want to sell, they're eager to get the process consummated. But I think it's critical that you spend time prepping. Again, there's no hard rules to this, but I think the prep process can take anywhere from 2 to 3 weeks. The marketing process, 2 to 3 months. The marketing process can also take from 2 to 3 months, as well as the close. So we typically tell folks to anticipate a sale process running anywhere from 5 to 7 months, 6 to 8 months, depending again on the type of process that the client wants to implement.
That's a great point, Brad, too, because I run in a lot of times where the client is already wanting to have conversations with particular buyers before you really are prepared or have your SIM done. And we really hate that. We counsel again, because you can only make one first impression.
You're absolutely right, Tom. And you always, as a seller, want to make sure that you know more about your business than the buyer, which sounds goofy, but ultimately the buyer is going to end up studying all sorts of aspects about the business that most sellers don't focus in on because they're so busy running the business on a day-to-day basis. So doing a quality of earnings, doing a tax review, going through your contracts, really understanding all the different issues that are going to come up during that, what I call preparation phase, is really a worthwhile investment of time and money.
You know, you bring up the third phase of the closing phase, and I think that's when the seller is most vulnerable. And we often, and that can just stretch on. When you gave those lengths, it's usually the closing phase that ends up stretching on. And I think that's a lack of, a lot of times the people in the deal, the investment banker, the lawyers really got to kind of push urgency and also do upfront, as you're advising, like the diligence and get other things done so that the deal just doesn't drag on and the contract takes too long and getting the UC, all the little detail work.
Agree. Go ahead, Phil.
No, you go ahead, Brad.
I was just going to say, again, not that there are any hard and fast rules to this, but essentially a seller loses all leverage, not all, loses significant leverage, let me say it that way, once they go exclusive with someone. So to the degree you can push off that exclusivity, resolve as many contract issues, diligence issues as possible to keep that close period as tight and as focused as possible, I think the better off it is, certainly for the seller. So you're right, Tom.
Yeah.
The one thing I'd like to overlay is I don't think anyone mentioned explicitly, pre sale process before you get, there's a lot of times a business will come to me a couple of years before they want to sell. They're planning ahead and they know they want to have some kind of a liquidity event. But they also know that there's some serious housekeeping that needs to be done, maybe some restructuring, maybe some, overall improvements to the business, to the processes. And so I've seen, I think thoughtful owners will really start to prepare as much as a couple of years before the actually, hiring a banker to start a sales process.
Yep, good point. We were covering a lot of that on the first part, but you're absolutely right. Whatever you can do to reduce the risk is going to ultimately raise your price and multiple. Jonathan, because you spoke up, the next one's coming to you. The legal structure of the sale of a business is usually in the form of an asset sale purchase or an equity sale purchase. What are the basic differences? APAs are more common than SPAs or MPAs. Why?
Well, in an asset sale and asset purchase, the buyer acquires the specific assets and liabilities of the business rather than purchasing the business entity itself. We talk in terms of, acquiring substantially all the assets, but the point is you're acquiring assets, you're not buying the legal entity. Liabilities that can be assumed by the buyer in an asset sale purchase are typically limited to specified liabilities. So if I'm the buyer and I want to buy free and clear of other liabilities, as long as we're leaving the risks like buying from an insolvent a company that may have an insolvency issue. If you're not dealing with that, I, as the buyer, when I'm buying assets, get to delineate which liabilities I'm assuming and which liabilities, and any liabilities I'm not explicitly assuming are being left behind with the legal entity that's selling its assets. Same thing with, contractual obligations. A downside of the asset purchase mode as opposed to an equity purchase mode is that usually you've got to have individual transfer agreements for you have to have individual assignments and assumptions, and counterparties may have the right to say, no, I don't want my contract assigned. transfers of licenses are necessary. An equity deal is the polar opposite. An equity deal, the buyer acquires the ownership interest of the business entity itself. So the buyer is the new owner of the entire business, of the equity, whether it's stock or LLC interests. And so all assets, all liabilities, all obligations of the company stay with the company. It's only the owner of the company that changed. Equity sales and purchases, equity deals generally involve less paperwork than asset deals because it's the entire business that's being transferred as a single entity rather than, maybe individual assets being transferred. But APAs, asset purchase agreements, are more common than share purchase agreements or membership purchase agreements in the context of an LLC for a variety of reasons. And I guess I already enunciated some of them,
Yeah,
right?
what I found in practice, it comes down to is it's kind of a pro and between liability. How important are the liabilities? Because they're going, if the liabilities are an issue, somebody's going to want an asset sale. If there's a lot of, like, for instance, tax loss carry forward, and if for tax reasons, they may want a stock sale. But generally, in a smaller sale, a lot of times asset sales, you get into public companies, it's almost always going to be an asset sale. But it's kind of a tug of war, the return on between liability assumption and tax issues. I don't know. Everybody else sees similar.
I think you meant with public deals, Tom, they're almost always equity stock deals.
Yeah, that's right.
I also think and this ties into the whole pre-planning phase, Jonathan, that you mentioned, that we too like to they have the opportunity to do. We like getting involved with our clients as early on as possible, given our long-term orientation. But you really have to do tax planning as well. What are the tax implications of selling stock versus assets? And you really need to evaluate that prior to coming to market and making sure you get the right structure, which ultimately ties into, are you better off doing an asset purchase agreement or a stock purchase agreement?
From a investment banker, it can sometimes switch at the end. It makes a big difference because a stock is considered a security, and an asset is not. So it's governed by the security laws when it's a stock sale, and there's a whole different mechanism of laws you got to follow. Let's dive a little deeper, Phil. We're going to warm you up here into the APA. Start by describing the major components of an asset purchase agreement and their purpose in the transaction.
Okay. The first thing I'd start off with is every transaction is different. And I know we've all seen it where somebody will come to you and say, this ought to be simple. What you've got to preach here is patience to go through the transaction. And y'all have talked about that, so I'll just move on. But the major categories that I see, first, are what's being purchased. If we're doing an APA, what assets are being purchased? If it's a merger, that's not really an issue unless you're carving some assets out. And I know we've all been involved in transactions where even when it was a merger, we knew that the company acquiring didn't want to acquire certain assets, so you had to divest those assets prior to the merger. And so you'd have to work through that. The next would be the purchase price. What kind of consideration are we talking about? Cash, stock? That's going to depend a lot on what's in the agreement, depending on what kind of consideration is being paid, when it's being paid, how it's being paid. As Jonathan, or I think it may have been Brad, mentioned, liabilities that may be being assumed and how we're going to work through that transaction. Next big category would be representations and warranties. And a lot of your representations or warranties are going to be dictated by the type consideration that's being paid. Again, if it's a cash deal, the seller's not as worried about the representations and warranties of the buyer because all they want to know is you got the cash and you're going to give it to me. If it's a stock deal, then you've got to go through all of these representations and warranties to protect yourself receiving the stock. Same thing on indemnification. What's the term of the indemnification? What's the scope of the indemnification? Are we talking about a holdback, a part of the purchase price in event there's a call on the indemnification provision, and how that's going to be paid out? Next, we would get into covenants, would be another big topic. And I'm hitting these on a high level, Tom. I mean, we could spend forever on each one of these
Yeah.
topics, but the covenants could include covenants not to compete. It could include the key person provisions that were talked about earlier about employment and consulting. What are we doing there? Then you get into some of the closing conditions, pre-closing and post-closing conditions, and what those are.
Yeah, I
One,
think we're gonna hit, I think we're gonna hit a lot of these in the next question, but that's
Yeah.
an excellent answer, Phil.
okay.
Thank you.
But
So
Just two things. Give me 2 seconds.
Oh, go, keep going.
Definitions, I think, are really important. You can't lose those. And then the default provisions are very, very important too. And just want to mention something because I see them a lot in my industry, and that's breakup fees, where somebody comes in after a deal's been done, and to protect the boards, you've got a breakup fee because if somebody comes along and makes a better offer, the board's able to consider it, but they've agreed to a breakup fee in the event they accept that offer. That would be it.
Huh. Okay. I'm gonna go the next. Now we're gonna get a little bit more into reps and warranties. And this is to Brad. Brad, what are the most critical reps and warranties a seller should be aware of? And what are the potential consequences of breaches?
So in terms of reps and warranties, it really has to follow, it's really ultimately all about risk allocation. Who is assuming what risk and at what time period? So I really view reps and warranties as about, again, assumption of risk, who wants to take it. And typically what people assume is that the buyer will assume all the risk, whether it's for receivables, inventory, whatever the business issue might be, they'll assume the risk post-close, while the seller should assume the risk pre-close. And it obviously has a huge impact on the purchase agreement, whether it's an asset agreement or a stock agreement. The other thing I'll mention, and this has been an interesting evolution, 15 years ago, 10 years ago, there was rep and warranty insurance out there for large deals. But the middle market deals where we play, deals anywhere from, 25 million of enterprise value to 500 million of enterprise value, you couldn't get rep and warranty insurance. Now that you can get rep and warranty insurance for these more, what I would call middle market deals, people are not negotiating the reps and warranties, again, whether it's a stock purchase or an asset purchase agreement, with the same level of intensity.
Great point. And that's a big change. Jonathan, just to kind of add on, just focusing a little bit more on the sellers, is what are the and Brad covered a lot of this, but what are some common representation and warranties that sellers typically make in an APA, and how can they prepare to ensure they are accurate?
Well, there are some fundamental reps like title. I, the seller, own all the assets that I'm selling. And authority. I, the seller, have a corporate authority to enter into the agreement. There's reps as to the accuracy of financial statements, as to compliance with applicable laws, taxes. There's typically a rep that, all tax returns are filed and all taxes that were due have been paid. There's reps as to the good standing of contracts, material contracts, the disclosure of all the material contracts, and the further rep that they're all in good standing. There's typically a rep as to litigation. You'll typically see in the APA itself, something that says there's no pending or threatened litigation, except as disclosed on Schedule B. Schedule X. And Schedule X will often say none. Or if there is litigation or threatened litigation, the disclosure will go there. And that's true for many of the reps. So the rep, it's common to see an APA where the formulation for each rep is except as disclosed on Schedule X, and then hopefully Schedule X doesn't have any exceptions. Those are, oh, and
Good
then
answer.
another very common one is a rep as to employees, you know, all employee obligations have been paid and et cetera, like, et cetera.
Yeah. Phil, we'll kind of give you the other side of the coin on buyer representations, and to protect themselves from unforeseen liabilities, what reps and warranties should buyers insist on?
Well, one of the things that they need to be careful with are when we start having representations and warranties by the seller to the seller's knowledge or to the best of their knowledge, and the wording on that, because essentially what you're trying to do there, like Brad talked about, you're trying to shift the risk from the seller to the buyer. And so you've got to be careful on knowledge issues in the allocation of that. From the standpoint of indemnification, you need to make sure that the seller's indemnifying the reps and warranties. So if there are breached, that you've got an indemnification claim. From the standpoint of closing conditions, I think you've got to protect yourself as a buyer to be able to walk away if there's a material change in the representations and warranties by the seller, and being able to protect yourself. And those would be the bigger ones. But I think it's key, and we've touched on it a little bit, and Jonathan hit on it in particular with a schedule. I see schedules in APAs in merger agreements playing a real active role, because in my experience, sellers have a tendency to forget about key things until they start filling out those schedules. And then all of a sudden you have a seller saying, well, what about this? What about that? So having schedules to your agreement that they've got to go through and think about these representations and warranties and covenants in detail, I think are very important to protect the buyer.
Excellent answer. And those schedules are one of the things we were talking about before that can delay a deal. So the more you can kind of start getting, those can take a long time to prepare accurately. So the more you can get ahead on things like that, the better chance you can close quickly. We'll stick with you, Phil, and we're going to kind of speed it up because we've got a lot of points on
Absolutely.
these APAs, and you guys are doing great with this. Covenants. Could you explain the role of pre-closing and post-closing covenants in an APA, and give examples of typical covenants?
Well, pre-closing covenants basically are meant to help ensure that the company is being run in the ordinary course of business. And that's really what the big purpose is, and that you're going to operate it consistent with past practices. What you don't want to do is start to buy a company and all of a sudden they start changing their practices to make the company look more attractive. Another one would be is that from a material respect standpoint, that they're going to conduct the business in an ordinary course of business. An efforts clause that they'll continue to operate the business in their best efforts, and making sure that if you see the wording, except as otherwise provided in the agreement, that it's not taking something away that you think you're getting in one provision. So I think that's important from a pre-closing. Post-closing really goes more to protecting the company after the transaction, and that you're still compliant. Let me back up. Pre-closing would be all the representations and warranties are still good as of the day of closing. You want to make sure that you carry those forward. But post-closing would include covenants like from the seller stockholder on non-disclosure, confidentiality, non-solicitation. If it's been a contested process, then you probably are going to want to work in early on a non-disparagement clause, because what you don't want to have is a seller start talking bad about the buyer post-closing that doesn't protect the business asset that's just been purchased. And that would be it on a high level.
Very well done, Phil. We're going to go to Jonathan for the next two. Indemnification provisions. How do indemnification provisions function within an APA? What are typical thresholds and caps that are negotiated?
That's a compound question. So indemnification provisions are designed to protect the parties against losses arising from the breaches of reps, warranties, and covenants. We talked about reps and warranties and covenants, but you make them, a party makes them, say the seller makes them, and then it turns out that their breach. Either they were wrong, or in the case of a covenant, the seller does the opposite of what he said he would do, or doesn't do what he said he would do. So the reps, warranties, and covenants are basically promises one party makes to the other, either about something in the past or something in the future. And the question is, okay, what happens if the promise is broken? And an indemnification provision is a nice way to answer the question. I'll give you an example. Let's say Fred sells a bowling alley to Barney, and Fred reps and warrants that the bowling alley owns 100 bowling balls. Turns out after closing, Barney discovers, nope, there's only 90 that are owned by the bowling alley, 10 are actually leased from a third party. Leaving aside a bunch of questions like, why did Barney only discover, the missing balls after closing? It seems like something his diligence should have maybe uncovered. What are his remedies against Fred? In the absence of an indemnification provision, can Barney sue Fred? Sure, he can sue Fred, but there's a whole bunch of questions and issues that can arise that would have been obviated if a proper indemnification provision had been included in the agreement. So what do I mean by a properly written indemnification provision? Properly drafted, an indemnification provision should include a bunch of elements, a scope. It should specify what losses are covered, and including whether or not, if I have to go sue you because I'm suing under the indemnification, do I get costs for my legal expenses in suing you? Survival, how long do I have to bring a claim? What if Barney doesn't discover it for 4 years? That's probably ridiculous. He should know sooner. You asked about, I think you asked about caps and thresholds.
Yeah, well, your next question is actually on that. What are common limitations on liability that sellers seek, and how can they impact the enforceability of the agreement?
So it's two separate. So within the context of indemnification specifically, you could put a cap on. You could say, all right, fine, I'll indemnify you, but only up to a certain amount. That's a cap. Or a threshold. I'll indemnify you, but not until your claims exceed a certain amount, because of course I'm going to get something not right. So you can't bother me for de minimis stuff. So absolutely, there are, in the context of indemnification provision specifically, there are those sorts of things. And we could have and there's different ways to write them. There's a deductible basket versus the tipping basket, where the former is it's a fixed amount. The buyer has to incur losses before it can claim indemnification. It's kind of like a deductible with insurance. And then, but it's only for the dollars after the threshold. A tipping basket is the opposite. Once losses exceed the threshold, the seller's liable from $1. And caps are caps. But the outside of it would include the context of indemnification, but even more broadly, sellers will seek to limit their liability in the context of an APA. There's other ways to do it. There's exclusion of certain damages. So, seller will frequently provide language that explicitly excludes indirect, consequential, punitive damages. That's not just in the context of an APA. It can be in the context of any commercial contract.
I think what you're making a point here overall is just how important it is to have experienced lawyers like Jonathan and Phil, because there's so many nuances and it takes so many experiences and there's so many ways to skin the cat. And I think also what it gets to, everything comes up in a deal. This is why it's so hard to close a deal, because everything you never thought about, every potential liability comes up. and has to be negotiated, and the parties can start to get wary. And that's where the job of like Brad and myself as investment bankers often are to kind of keep the parties together and make sure that these issues don't explode and the deal kind of doesn't close. So Brad, I'm going to kind of jump to you now on the next one, which relates to that, and it's closing conditions. And what are standard closing conditions found in an APA? And how can both buyers and sellers effectively manage these conditions to ensure a smooth closing?
Essentially, closing conditions are requirements that both parties must meet to consummate the transaction, of course. Buyers typically want there to be lots of closing conditions. Sellers often want there to be few. Because if the conditions aren't met, then the transaction does not need to be closed. The big categories I find are making sure you have proper regulatory approval, that you have the financial means to close the transaction, that you have proper and demonstrated title of assets being transferred, that you have met all the legal requirements necessary to close the transaction, and that you have third-party consents. And to go to Tom's point, this is an area, especially in terms of getting consents, transference of certain contracts that might be required, where you can't communicate enough with the seller. We've run into situations where we just couldn't get the proper consent. We were involved in a transaction where we needed to get the transference of an easement from a Class 1 railroad to the buyer. Getting a Class 1 railroad to respond to anything in a timely fashion is a challenge. And we had to be very upfront with the buyer, who was sensitive to the issue, and structure around getting that easement transferred in a timely manner. So keeping the communication open throughout the transaction is critical, but often at the end, Tom, to your point, where folks are fatigued and just want it to be over and are weary, is really critical, because you don't want one contract, one easement, one approval to derail your transaction, which can
Excellent
happen.
points, Pick. Escrow agreements. This is to Phil. How are escrow agreements typically structured in business sales transactions? And what role do they play in addressing potential post-closing disputes? Phil, you're muted.
I'll sum it up quick for you. I'm sorry about the mute. You've got an escrow agreement in place. You carve out part of the purchase price, you dump it into an escrow account, and it's basically there to satisfy claims that the buyer may have through the indemnification provisions or breach of any terms of the agreement. And it's there. Typically, you'll see those, at least I see those, being structured where the money's being held for a period of time, and you may release it in stages. For example, if it's being held for 3 years, you'll release a third the first year, a third the second year, and a third the last year. And that's under the assumption that the claims would be diminishing over time. And so you'd be pushing the money out to shareholders. Again, they're negotiated between the buyer and seller, but it's really a cash equivalent of damages in the event that there's a dispute that arises from the buyer standpoint.
Yep, good points. Okay, Jonathan, MAC clauses, material adverse change clauses. How is a MAC clause defined? And in what ways can it affect the closing of the transaction? And a bonus question, would you consider the pandemic, the COVID, as a MAC condition?
Okay, so MAC is also referred to as an MAE, depending on who's drafting it. They mean basically the same thing, material adverse event. And the idea is that a MAC or an MAE provision allows a party, usually the buyer, to back out of the deal if significant negative changes occur between sign and close. It effectively serves as a protective measure, allowing, the party for whom it's drafted, for whom it's intended to protect, to to avoid those risks. And to be clear, I just said it, but I'm going to say it again. there's a material difference between a simultaneous sign and close deal versus a deal where there's a signing, today, and there may not be a closing for 30, 60, 90 days because there are conditions to closing that have to be satisfied. And so in the context of a simultaneous sign and close, you don't really need the concept of a MAC or an MAE provision. But the the non-occur and when there is not a simultaneous where they are separated, it's a MAC is commonly included as a condition to closing. So, condition to closing number 4, no MAE or no MAC has occurred. If it has occurred, the condition to close is not satisfied, buyer doesn't have to close. And the definition of what actually, and here's the heart of the matter, the definition of what actually will constitute a MAC and MAE is usually subject to a bunch of negotiation. And it may, in fact, you commonly see it based on significant events that impact an entire industry or the economy as a whole, as opposed to things that are very specific or unique to the company in question. But again, it's negotiable. So to your point, the bonus question, most of the, would that be, would the pandemic have been a MAC? It's a close cousin to the question of whether in other commercial contexts, whether it would have been what's the Latin for term I'm looking for? An act of God clause. Can't think of the name.
Force majeure.
Thank you, force majeure. So you're effectively, force majeure got litigated in a lot of commercial contracts. Force majeure is a provision in a lot of contracts that basically say, yes, I'm supplying you widgets, but if there's a war or if there's a pandemic, if there's these massive things happening, then force majeure will excuse my performance. So you're kind of asking the same thing. I don't have an answer, but I
That's a
believe
good answer. What you didn't also a lot of times there's like a threshold of materiality, like it needs to be over $1 million or some dollar. I've seen a lot. I think so
that's true. Oh, the last thing I wanted to point out is a MAC in practice, in real life, in the context of an APA, it doesn't necessarily, the occurrence of a MAC doesn't necessarily mean the transaction will be terminated, because the occurrence of a MAC can, give a buyer the ability to say, all right, look, I have the right to terminate, but if you're willing to negotiate some terms, even though we thought we had a deal, I'll waive the MAC. So it can often lead to renegotiation of some of the terms.
Great point. Great point. Brad, the due diligence process, and I think here we're kind of talking about the end when there might be the buyer brings in an accounting firm maybe to do a diligence, and maybe the seller's done a sell side. But how does the due diligence process influence the drafting and negotiation of the asset purchase agreement?
So this gets into process and just my theory on running processes. I think you are always better off doing, as I said, as much work up front as possible. The asset purchase agreement, stock purchase agreement should really reflect the business asset and what you've disclosed. So in terms, again, of risk allocation, if you have said to a buyer, hey, this is not an issue, then you shouldn't have to rep and warranty something that's not an issue if you've been able to demonstrate that. It also ties into how do you share information with the market as you go through your sale process. And that's a critical phase as well. What you don't want to do is surprise someone, make someone uncomfortable with what you're selling. So to the degree you can understand your business, articulate the different attributes of the business in the sales memo, then in the management presentation, then you should be able to essentially get what I would describe as a cleaner contract. Again, the contract has to reflect the diligence that's been done. So the more diligence that someone can do, the cleaner the contract in theory should be, and the cleaner of a process to close that should ensue.
I think also, like, going back to John, if Fred and Barney with the bowling balls, and that's a major thing that they have the right amount, that's something the asset purchase agreement's going to want to address, because it came out in diligence that, so it should make sure it kind of eliminates future disputes and areas of disagreement.
So with the bowling balls, what I would try to orchestrate is count all the bowling balls, Mr. Buyer, prior to close. Let's do that before we enter into a letter of intent and give you exclusivity, so that we don't have to, we'll give you a condition that we'll have those, but I don't want to create a rep and warranty and have a problem. So do your due diligence up front, to your point, Tom.
Right. And then also you get a lot of times, and I find this is often not addressed enough and left to the end, is kind of a working capital provision where there can be a reallocation, and there can be a lot of shift in the purchase price, just in what is the normalized working capital, and is so that's an area I think that often kind of gets overlooked to the end, but is often can be very critical.
I totally agree. And I always say that working capital adjustments should not be a vehicle for the buyer to grab onto additional value, or for the seller to grab onto additional value. And again, there's no hard and fast rules, but typically I'll tell a seller, let's talk about our working capital during the management presentation. And let's agree as well on a definition, so that there's no confusion. What is in working capital? And often with our asset purchase agreement, stock purchase agreements, I'll have a separate schedule, or I'll suggest to the lawyers, the guys like Jonathan and Phil, that we have a schedule with real numbers, so that there's no confusion about what constitutes working capital. But
Yeah, that's really good, Brad. Let's go employee issues. And Jonathan, I hope you don't mind taking this one. But what are typical provisions regarding the transition of employees, and what complications can arise in this area?
Well, we touched on this so a little bit, so I'll try not to be repetitive of what we covered. The APA will often address which employees be retained. Sometimes it'll be that none will be retained. It just depends on the circumstance. That's usually not the case. There may be separate. There may be, as closing conditions, a requirement to protect the buyer, that the buyer has entered into separate agreements with employees A, B, C, and D, because employees A through D are just so critical to the business that the buyer doesn't want to do the deal without them. Severance packages may be negotiated. The seller will sometimes negotiate severance packages as part of the sale agreement. There could be a notification provision that contractually obligates what kind of communications will happen between signing and close. Non-competes, non-solicits might be required. Things like that.
This kind of goes to, and I think, Brad, you probably see that I get worried at the end of a deal often that all the leverage goes to a particular employee, and they can almost, kind of decide whether the whole deal so you have to be really careful. It takes a lot of art to kind of land this thing and make sure that it works because there's so many different parties coming together. I've had deals at the end where certain key managers just holding out, to get a little bit extra and leveraging that position.
Yeah,
No question.
Tom, along those lines, I was involved in a transaction not too long ago where I kept pushing both the buyer and seller to work out the terms with those employees. And they provided the information the day before closing and expected it to be signed the day of closing. And my comment to them was, I can't control the employees. We've been talking about this for months. And if they decide not to sign, there's nothing you can do about it. They walk away. And at that point in time, you're headed to a dispute. It actually worked out in this instance because uh, there were good terms for both parties. But if somebody had really been trying to use their leverage, you're right. I mean, the transparency there wasn't there, and you did that to yourself.
Yep, great. And Phil, because you did such a good job on that, and giving you the next one. Intellectual property, what specific considerations should be addressed in the APA when dealing with the transfer of IP?
And I'm going to make this really quick because I know we've got some other stuff that we want to cover. This is what I'm going to tell you. This is a specialized piece of collateral. You need to make sure that the people that are advising on it are experts in that area. But you've got to make sure you've got ownership issues protected. You've got to make sure that if there's any license agreement in place, that you're protecting yourself there. And then you've got to make sure that there are not lawsuits involving a dispute as to ownership or use. And those would be the big issues in my mind. But make sure you get qualified people to advise on those particular issues because it is a specialized piece of collateral. I mean, asset. Excuse me. I was getting back in my lending. Specialized asset.
Yep. Jonathan, next one's for you. Real estate and leases. How are real estate and lease transfers handled within the framework of an APA?
Well, if the seller is the party to a lease, if it doesn't own the real estate it operates out of, then you're dealing with usually an assignment of a lease or assignment of leases. And most APAs are going to include provisions for the assignment of leases. Often, almost always, it's going to require the consent of the landlord because that's what the lease between the landlord and the seller says. And it's common for sellers to remain liable for lease obligations, at least prior to the closing, of course. And when you're dealing with the added accoutrement of a lease, you're going to have to, this is a little bit of a detail, but you'll need to possibly make adjustments for, the existence of a security deposit, prepaid rents, that kind of thing. That's in the context of leased real estate.
Yep, I think it complicates it a lot because sometimes the real estate is owned by separate parties. I think the seller needs to think about if he wants to continue to own that and have the new buyer as a tenant and how that's going to affect their relationship for a bunch of other things. Also, real estate, I'm seeing more and more that it can delay the deal if you don't really have it all in order up front, including doing a phase 1 and potentially phase 2, because those things take time. And again, if you're kind of trying to do that at the end of a deal, that can really delay it. Speaking of stuff along those lines, regulatory approvals. Jonathan, what types of regulatory approvals are commonly required for business sales, and how should these be addressed in the APA? I know Brad mentioned that before.
At the lower middle market, often few. Antitrust approval for larger transactions is common. And if you're going to get into a situation where competition will be impacted, depending on the industry, there's industry specific licenses and approvals that may be required. Heavily regulated industries like healthcare, telecom, energy. And so transactions may require regulatory approval from the relevant bodies. If there's foreign investment involved, approvals from government bodies may be necessary, particularly if we're dealing with an industry that has any sort of national security implication, which can be more expansive than one might think, i.e., a la TikTok. Has been analyzed in that way. And then we uttered the words environmental before, If the business involves hazardous materials or significant land use or environmental impact, then there may be stuff in that regard to worry about.
And this goes to Brad's point too about trying to handle these things early, because I've seen deals where you're scrambling at the very end it can submarine an entire deal that really could have been taken care of routinely, but you're trying to get a government agency to do something on the fly at the end. It's definitely not the way to handle things.
That's right. And to that point, the document can specify who is to do what level of efforts, i.e. best efforts, reasonable efforts. You can specify the expected timeline for receiving approvals. All that stuff can be used to help make sure the process runs more smoothly.
Okay, Brad, here's a tough question for you, but important. What are key tax considerations that should be addressed in the asset purchase agreement?
Sure. I just wanted to just add on to what Jonathan said in terms of environmental. Understanding, though, how buyers look at these environmental issues early on is really critical, because you might have a buyer who wants the seller to take all the environmental risk, but is willing to pay you $10, while another buyer will pay you $8, but assume more of the environmental risk. So you always have to look at price and terms. And that's why I always like to get a markup of a purchase agreement, sort of the final round of bidding if possible.
Right now, just because this is something I'm learning the hard way a lot of times. Environmental are really tough issues because you can't really push away that liability. Even a bankruptcy, the liability, even if you're a tenant, the super fund law, the environmental liability kind of touches everybody and everybody's liable. So it's something that it's hard to contract around.
Agree. In terms of tax, my answer is going to be a lot like Phil's with respect to IP. I think most business owners are thoughtful about paying their taxes. At the same time, that doesn't mean that when you go through a transaction process, everything is, shall we say, tied up and neat. I sold a division for a multinational that discovered during the due diligence process that they had not been paying certain state sales tax in a state like, a state that didn't have a lot of people in it. And that was going to create a major timing issue. So to the degree that you can understand your current tax position, asset versus stock, understand, have you paid all your taxes, which sounds goofy. And when you say that to a seller, they're like, of course I've paid. But there's all sorts of taxes, obviously, whether it's sales tax, state tax, you want to make sure you're current on. The other big thing that we're seeing a lot of folks spending time on is making sure that employees are properly classified, especially in industries that rely on independent contractors. Is it appropriate for them to be 1099s, or are they supposed to be W-2s? And who's going to take that risk? So a lot of complexity in tax, and there's really no one simple answer to it. Yeah. I don't know if Jonathan or Phil, you have anything to add to that.
Well, I'm going to push to the next one, because when things don't go well, even though we've covered all these things, Phil, how are disputes typically handled post-closure according to an APA, and what mechanisms such as arbitration or mediation are preferred?
Well, I see different levels. You mentioned mediation or arbitration, but let's step back from mediation. I've seen some agreements where the parties will agree on an accounting firm, for example, that may be able to resolve a financial issue without truly mediating a claim. But other than that, it would move to mediation and arbitration. And the biggest issues there, I think, is the desire of the parties to keep the information confidential and not have it publicly played out in a court. My comment, and this is a real personal comment, so I apologize on the front end, is I find arbitration to be a calculated risk in a lot of instances, because if you're not careful with who the arbitrator is, you can end up with a decision that's not appealable. So you need to make sure that you've carefully considered mediation, not so much mediation, but arbitration as a final determinative factor, because it does have adverse consequences if in fact you think you've been wronged. But what I see is mediation, arbitration, or an outside third party serving as somebody to resolve disputes between the parties.
I'm going to just change the final question here because we're getting, and this is, you guys are so knowledgeable and I just, and done so many different transactions. Just a kind of a question to both John and Phil and then to Brad different, but John, as a lawyer, what are the key of your role? You know, what do you see as the key to kind of getting a successful deal to close? You know, it's a general question, but I'll let John and Phil, it's a jump ball for you, and then Brad is an investment banker.
Jonathan?
Well, I think this probably crosses the line into what bankers do too. But hey, listen, it takes a village, right? It's to make sure that my client, doesn't just have self-perception, but also can have perspective of the, where the other side is coming from. More often than not, when the other side comes out with a position, articulates a position, I don't care what it's about. If we don't ask if we ask, what's driving that view, if we could understand the world from the other side's eyes, we often can figure out a solution that, other side might be asking for X and we're saying, no, it's Y, but there's a Z out there that's a possible compromise. And you're going to get there a lot easier if you have the ability to assume the other person's perspective for a moment.
Outstanding. And Phil?
You know, I wrote down 5 words, so I'll go through it quick, Tom. I think you got to have a process to begin with. You've got to be able to adapt with that process as you move through the transaction. And as Jonathan said, in a different way, but you've got to listen to what the other party's saying. You've got to be able to understand it. If you're not listening and you're only focusing on your goals, then you're going to miss opportunities to be able to find a way to compromise something where there is some win-win or there may be some lose-lose, however you want to say it. But at the end of the day, if you can walk through a transaction with that process and listen to what's going on and find ways to make adjustments and compromise where parties can compromise, then you can get to a closing that's going to have equity in it. And that's probably the best you can hope for as you get to the end of the day. And both parties may not be excited about everything, but they're happy with the end.
That's great, Phil. Brad? You got to unmute. There he goes.
Yeah, I'm a big believer in establishing I agree with what Jonathan and Phil have said.
Yeah.
But just to try to add some additional points, at the end of a process, creating real milestones, and making sure that everyone's being very, very realistic about timing. You do no one any good by saying, hey, we can close this in 24 hours, and it's going to close in 2 weeks. And again, I think over communicating is critical. There's a point in the transaction where it is appropriate for principals to be talking to principals and where lawyers should be talking to lawyers. And I think the worst thing to have happen at the end of a transaction is for there to be inadequate communication. So we're big fans, especially once we've gone exclusive with a buyer, of having weekly calls. And at the end, if you need to have a call every day to address the 3 open points, then do it. The less ego that gets involved in a transaction, I always say, the more likely you are to get the transaction.
Yep. That's a great answer. And I'll kind of echo what everybody's saying, but I think from an is to run a process if it gives the chance for the best possible outcome, that you're controlling it, you're taking care of the contingencies up front and making sure that there's a competition that allows them, but also to have flexibility and get over the breaking points. Because as you can see, there's so many things come out every deal, even when people think they have an agreement, times change, and the role of an intermediary is where they really earn their dollar is when they can bring the parties back together and find agreement. Now, you do have to have both parties really want to close the deal. If you have one party start to want to be out of the deal, probably not going to close. So you need to be realistic, but it's to kind of bring everybody together. And I think, Phil, you said it well. Maybe everybody doesn't think it's the best deal, but everybody's happy about it. And there's something, and that's that's how you get a deal closed. This has been a great seminar. This could have gone on for days and days with the knowledge in this room. And this will be online for people to see later. And thank you, everybody. It's been an honor to be part of this. Thank you, Financial Poise, for putting this wonderful educational series together. Thank you to John, Phil, and Brad, and our panelists before. This has been outstanding. Thank you. That's the end of our webinar.
Thank you.
Have a great day. Thank you.